My name is Tiffany Jones, and I am an associate at Peterson, Johnson & Murray, where I primarily practice civil litigation. I would like to speak with you today about the Act of God defense and whether the defense still exists in modern day. Law students may have learned about the Act of God defense in their law school tort classes. The defense may seem archaic and obsolete to most. True, although the defense is not invoked very often, the number of modern decisions interpreting the Act of God defense has remained constant. Nowadays, with the rise of catastrophic weather-related events, we may see a corresponding rise in the use of the Act of God defense. Act of God, in its legal sense, means such inevitable accident as cannot be prevented by human care, skill, or foresight. Black's Law Dictionary defines vis major as a greater or superior force, a loss that results immediately from a natural cause without the intervention of man and could not have been prevented by the exercise of prudence, diligence, and care. In other words, the defendant must show that no matter how much prudence, diligence, or care it demonstrated, the damage could not be prevented. This complete exclusion of human cause is a very difficult standard for a defendant to overcome, which likely explains why the defense is not commonly argued or upheld. As a result, modern courts sometimes characterize acts of God as unavoidable accidents, because although the terms may seem synonymous, unavoidable accidents do not require the complete exclusion of human action. The case Lee v. Milwaukee Gas Light Company demonstrates the difficulty in proving the Act of God defense, yet this case provides the possibility that the defense could prevail if the conditions were right. In Lee, the plaintiff was waiting for her bus on a sidewalk, standing about 6 feet from a building window. High winds that day caused the window to pop out and shatter. A piece of shattered glass entered the plaintiff's eye, and plaintiff sued for her damages. The defendant building owner argued that it was not foreseeable that strong winds would cause the window glass to shatter, subsequently injuring plaintiff. However, at trial, plaintiff's expert testified that the window industry standard in Milwaukee requires that window glass be built to withstand 65-mile-per-hour winds. On the day of the accident, the wind speed never reached more than 23 miles per hour. In considering whether wind speed could be deemed an act of God and the proximate cause of plaintiff's injury, the Lee court reviewed non-Wisconsin authority and the line drawn by those courts when determining what constitutes an act of God. For example, in a Texas Court of Appeals decision, a 36-mile-per-hour wind was considered foreseeable and thus not an act of God. Whether an 80-mile-per-hour wind constituted an act of God was considered a jury question in Ugla v. Brockow, a New York Court of Appeals decision. Interestingly, though, in King v. Queen Anne Foods Products, also a New York Court of Appeals decision, a lesser wind, a 75-mile-per-hour wind during a hurricane with only a 20-minute warning, was held to excuse the defendant. Because plaintiff's expert in Lee testified that windows should be able to withstand 65 miles per hour, and the wind speed on the day of the accident only reached 23 miles per hour, the Act of God defense was denied. Although the Lee court denied the defense, it left open the possibility that if the winds were stronger that day, possibly a 66-mile-per-hour wind, then the vis major defense may have precluded liability. And from a review of other cases around the country, whether strong winds or any related weather condition for that matter will be deemed an act of God becomes very fact-specific. And so the Act of God defense is as common today as ever. Even though it is not relied on very often, this is likely due to the difficulty in proving that human elements played no role in causing the injury. Considering the fact that major global events have been increasing in the last few years, including such events as Hurricane Katrina, the earthquake in Haiti, and the most recent earthquake, tsunami, and nuclear crisis in Japan, we may see the use of the Act of God defense also on the rise. Whether such acts of God will be deemed foreseeable will likely depend on the region and if such events had occurred in the region's most recent past. If the events and/or the magnitude of these events are not characteristic of the area, then the Act of God defense may prove to be a more successful defense in the future. Please check out the article written by Randy Parlee and Tiffany Jones, The Act of God, or Vis Major Defense, Does It Still Exist? Thank you.